A superintendent in Rhode Island, a school superintendent, has banned the father-daughter dance and mother-son ball games from her school district because of a complaint that they violate the state's discrimination law. We're joined by WGY legal analyst Chas Farcher of Martin Harding and Mazzati. Good morning, Chas.
Hey, Chas.
Good morning,
What
morning,
is
Chuck. Good morning, Kelly. How you doing?
what
Doing
is
great.
going on here? This is crazy.
Yeah, I think there's a good quote that came out of the Cranston School District: "Political correctness run amok," and that seems like what you got here.
Sure does, doesn't it? Do they have any legal leg to stand on?
Yeah, unfortunately, I think they do actually. There's the federal laws, which are commonly known as Title IX, prevent any school that receives federal funding from discriminating on a gender basis. So, the question here is this discrimination. I think the long and the short is, there's an exception specifically carved out in the law for this type of stuff: father-son, mother-daughter activities. Unfortunately, when the state adopted the essentially the same statute on a state level, they didn't include that exception. So they probably could have been safe under the federal law. Under the state law, maybe not so much. So absent some type of change to the state law, there seems to be a problem for the school district here.
So this mother has a child who doesn't have a father figure. So she came and complained and said, well, my child is being excluded because she doesn't have a father. Well, who's to say the mother couldn't go? Because essentially she's acting as the mother and father in that, in that household.
All right, and that seems to be the more common sense, reasonable response to this. If dad's not available, how about an uncle or an older brother or something like that? But the black and white law, the way it stands in Rhode Island right now, is you can't discriminate based upon gender. And apparently, because this girl didn't have a father, she was being excluded. But I agree. I think what's probably missed the context of this is that this particular school board had recently been sued by the ACLU for a different issue. Hanging prayer banners in the school, and they lost that battle to the tune of about $150,000 in legal fees. So I think rather than take on the ACLU again, the school board just decided it'd be easier just to do away with the activities.
Do you think that we could see this now spreading across the country and other school districts now doing away with things like the father-daughter dance or any kind of mother-son activities?
It's a possibility if for fear of losing battles to the ACLU, particularly given the economy and the way things are now. You have a lot of schools who don't have funds to fight these types of legal battles. But, realistically, one, there is an exception in the federal law. It is for father-son, mother-daughter activities. The only thing the school has to do is provide comparable activities for the other sex. So if you have a father-daughter dance, have a mother-son-daughter dance, one in the spring, one in the fall, whatever. As long as there are similar activities for both sexes, I don't think it's an issue. And most states that have adopted a state law that is similar to the federal one have that exception. Like I said, the problem is the Rhode Island statute. I guess the legislature's got a little lackadaisical and didn't include that like they probably should have.
So let me ask you this. If they had a parent-child dance and a child is being raised by a grandparent, would they be discriminated against because they don't have a parent?
Yeah, kind of crazy. Not under the laws that we're talking about here today because they're based upon gender, but you can actually really see the slippery slope argument here. If you have one diabetic child, does that mean cake should be banned from school? You're right, it gets crazy.
So what is the solution here?
Well, like I said, I think as long as schools provide equal opportunities for both genders, they can avoid this issue altogether. So, right, I think a parent-child dance is a great solution. Or, like I said, if you're going to have a father-daughter dance, have a mother-son dance. The following week, following month. Rhode Island, just this particular school district, having already lost one battle with the ACLU, I just don't think had the stomach to fight.
Well, that's kind of the bigger point too, where sometimes it's too costly of a fight, which is too bad because you're kind of being bullied into making your policies rather than coming up with the right common sense ideas.
I think that's exactly right, Chuck. And like I said, had this school not already lost, because it seems like they had the stones to stake on the ACLU last year,
Yep.
But had they not just lost a battle, particularly in this economy where schools don't have funds or enough money to pay teachers as it is, now they hit with a legal bill for the tune of $150,000.
WGY legal analyst Chas Farcher of Martin Harding and Mazzati, 1-800-LAW-1010. Chas, thank you.
Hey, thanks a lot, Chuck. Thanks, Kelly. Have a great day, guys.
You too.
Thanks, Chas. Have a great day.